still seems to be some confusion and some misinformation out there about this. So hopefully this presentation today will clear up any questions or doubts that you may have. And if this looks familiar, it's because it's essentially the same presentation I gave twice last year in May and October. So just a bit of background. Individuals and married couples are limited to one homestead standard deduction. As the receipt of this deduction becomes more beneficial, there is more incentive than ever for homestead fraud. Homestead fraud causes higher tax bills for all. Therefore, in 2009, there was legislation passed that required taxpayers who receive the homestead deduction to verify that they are eligible to receive the benefit and to provide additional identifying information necessary to allow county government to better monitor homestead filings. Each individual and his or her spouse, if any, claiming the homestead deduction was required to provide the last 5 digits of his or her Social Security number and driver's license number. This information has been used to populate a secure homestead database, which is being used by county auditors to track homesteads statewide and prevent fraud. This will help reduce taxes for all by ensuring that everyone shares equally in the property tax burden. This form, the pink form or verification form, was to be sent with tax bills in 2010, 11, and 12, and was to be completed at least once by January 1st, 2013. Now, what happens January 2nd? Okay, the program has ended. Now, this slide is very, very important, so I'm going to walk through it here very slowly. What if a taxpayer has not returned the form by the deadline? All right, under the law, and notice this is state law, this is not DLGF policy, this is state law, the county auditor may, in his or her discretion, terminate the deduction for assessment dates after January 15th, 2012, if the individual does not timely and validly file the form as determined by the auditor before January 1st, 2013. Before the county auditor terminates the deduction, he or she must mail notice of the proposed termination of the deduction to the last known address of each person liable for any property taxes or special assessment, or the last known address of the most recent owner shown in the transfer book. If a county auditor terminates a deduction because the taxpayer claiming the deduction did not comply with these requirements before January 1st, 2013, the county auditor shall reinstate the deduction if the taxpayer provides proof that the taxpayer is eligible for the deduction and is not claiming the deduction for any other property. So a few very important points here. This slide, if this is the only slide you take away from my presentation, that's fine. This is the most important. An auditor could potentially pull the homestead deduction for the March 1st, 2012 or January 15th, 2012 assessment dates, which means the 12 pay 13 cycle, which would be a permanent termination unless the taxpayer provides proof of his or her eligibility for the deduction for that cycle. If the taxpayer does so, the deduction must be reinstated. Under existing law, there is no deadline by which a taxpayer must provide this proof. The reinstatement must occur for the cycle for which the deduction was terminated for failure to file the verification form. In other words, pay 13 and perhaps beyond, depending on when the taxpayer provides the proof. Failure to file the verification form authorizes an auditor to terminate a deduction for pay 13 and beyond. It does not authorize an auditor to go back previous years and seek taxes and penalties. To do this, an auditor needs a reason separate and independent from failure to file a verification form. So again, just to reiterate, if someone doesn't file the pink form, you have the discretion to terminate the deduction for that reason. All right, so if Mrs. Smith, who lives down the street from you and who babysat you 42 years ago, didn't return her pink form, but you know that she's lived there all her life and that she's eligible for it, you have discretion to terminate her deduction. You don't have to, you may. And that's the extent of your discretion. If you decide to terminate her deduction, you have to send her a notice by mail before terminating it. And if she comes in and shows you proof of her eligibility after you've terminated it, you must reinstate it. You have an affirmative obligation to reinstate it. You can't say, well, I'm going to pull it for pay 13, I'll give it back to you for pay 14. Or if you fill out this form and give it to me, then I'll reinstate it. No, it has to be reinstated for pay 13 if the taxpayer provides proof of their eligibility. And again, if someone fails to file the pink form, that authorizes you just to pull the homestead deduction for pay 13 and forward. You can't say, well, someone didn't file the pink form, so I'm going to go back previous years and seek penalties and taxes. You have to have a separate and independent reason for that. So if someone doesn't file a pink form and you do some investigation and realize the property has been rented out for 10 years, that would be a separate and independent reason for going back previous years. But failure to file a pink form alone only allows you to pull it for pay 13 and going forward. All right, now, First two bullet points here, I think I've sort of already covered here. The third one, I know that a lot of you are probably sitting here thinking, well, that's not fair. We sent this form out for 3 years, and we sent out another form before we terminated it. Shouldn't there be some repercussion for those who didn't file the pink form? And I understand that sentiment. It was a lot of time and energy expended on this program. But you have to understand the purpose of the program was to identify improper or invalid homesteads, not simply to create a mechanism for pulling deductions from people who were technically eligible for them, but maybe were just negligent or lazy in returning the pink form. So I know it doesn't necessarily seem fair, but if somebody was eligible for the deduction, even if they failed to file the pink form, the idea is that they should be able to continue to have it because they were eligible for it. They were just lazy or negligent or just overlooked their obligation to file the pink form. All right, after January 2nd, 2013, when the pink form verification program ends, an auditor may still request information from a taxpayer to verify his or her eligibility for a homestead deduction. There was a legislative change last year that provides as follows. Basically, a county auditor may limit the evidence that the individual is required to submit to a state income tax return, a valid driver's license, or a valid voter registration card showing that the residence is the principal place of residence. There was an administrative rule the DLGF had that was voided last year. It listed a bunch of different documents that you could request. Now, the point here is that you may limit what you request to those 3 documents. You are not prohibited from asking for other documents if they might help evaluate someone's eligibility. The DLGF's administrative rule was voided, but that doesn't mean that you can't ask for other documents that might be helpful. Some people don't have a driver's license or voter registration card, so other things may be workable. And this is the same type of evidence someone could present to have the deduction reinstated if it was pulled because they failed to file the pink form. So if you pull the pink form and they come in and say, I was eligible, what can I show you? You can request those same 3 things: the state income tax return, driver's license, and voter registration card. Now, these are some frequently asked questions that I've received. What happens if the deduction being reinstated was originally issued years ago before the use of Social Security numbers and driver's license numbers? Can we request that information now? Well, again, to have the deduction reinstated, the taxpayer does not need to file more forms or jump through hoops or do anything else. If they're eligible, they show you the proof, they're eligible, it has to be reinstated. You can't make them fill out a form just for the sake of doing it. However, understandably, if the deduction was originally applied for 35 years ago before they were required to provide a Social Security number or driver's license number, if for the purpose of updating your records to make sure that the taxpayer gets the deduction now and going forward, if you need certain pieces of information, that would be one thing. But to say, here you have to apply for it from scratch or fill out this form, that's completely different. So if you need certain pieces of information to update the database or update your records to make sure the taxpayer gets this deduction, that's fine. But you can't make them jump through additional hoops. All right, now another question. For purposes of the verification form, if the taxpayer doesn't have a driver's license or Social Security number, the last 5 digits of a state ID number, or the last 5 digits of a control number on a document issued by the U.S. federal government, such as a passport or work visa, may be provided instead. These numbers are acceptable only if an individual legitimately does not have a driver's license or Social Security number and must be accompanied by an explanation of the type of number provided. Now, what if the taxpayer doesn't want to provide the last 5 digits of his or her Social Security number on the verification form? Can the deduction be removed? Yes. But remember, if the taxpayer subsequently provides proof that he or she is eligible for the deduction, the auditor must reinstate it. And one other point on one of the earlier slides, before you pull the deduction, you have to send a notice to that taxpayer. It has to be mailed. You can't just put an ad in the newspaper or on TV. It actually has to be a mailing to that taxpayer. Another question, for purposes of the verification form, what if someone provides an out-of-state driver's license number? Taxpayer is not required to provide an Indiana driver's license or identification card to receive the homestead deduction. However, if he or she provides out-of-state ID, the county auditor may request additional information be provided as proof, and see slide 7. That's the one that talked about the state income tax return, voter registration card, and again, there may be other things you can request that would help. Note that an individual has 60 days to obtain an Indiana driver's license after becoming an Indiana resident. So it's just a little FYI, if somebody claims to be an Indiana resident for 10 years but has an out-of-state driver's license, that could be a tip-off. Now, another question, when we remove a homestead deduction because the verification form has not been returned, should we remove all deductions except the mortgage, veterans, and geothermal deductions, since taxpayers receiving these deductions do not have to reside on the property? Only the homestead deduction would be removed so long as the property qualifies for the other deductions. So again, failure to file a pink form only authorizes you to pull the homestead deduction for pay 13 and going forward. To pull other deductions, you would have to have an independent reason for doing that. Going forward, how do we obtain information about spouses not mentioned in a deed? The sales disclosure form requires a buyer who is applying for a homestead deduction to provide spouse information in the penalties for perjury section. It says that spouse info, including a social security number, is not necessary if the buyer is not applying for the homestead deduction. Another question. We have a taxpayer who closed on December 31st and filed for the homestead deduction by January 5th. However, the deed wasn't recorded until January 2nd. Can he receive the deduction? Yes. It doesn't matter when the deed is recorded. What matters is that the owner was the applicant was the owner of the property at the time he applied for the deduction. He completed and signed the application by December 31st and filed it by January 5th. So don't get hung up on the date of recording of the deed. If someone's name is on a deed, they are the owner, whether that deed is recorded or not. So what matters is, did they fill out the form and sign it by December 31st, and did they file it by January 5th? And if they did so, then they may be eligible for the homestead deduction, regardless of when the deed is recorded. Another situation we were presented with here. The following is based on a fact pattern whereby a homestead deduction that was validly in place on March 1st, 2012 is terminated for failure by the owner to file a pink form on or before December 31st, 2012, such that an unqualified new owner who purchased the property in July 2012 would not receive the benefit of the homestead deduction that was, at the time, validly in place on March 1st. Yes, in this circumstance, and it's a narrow one, the homestead deduction could be terminated for the 2012 assessment date. The pink form statute created a unique situation that allows a homestead deduction that was validly in place on March 1st, 2012 to be removed for 12 pay 13 simply by virtue of failure to file the pink form. The statute allows the auditor to remove the deduction for an assessment date after January 15th, 2012 if the pink form was not filed for that property on or before December 31st, 2012. If you sent a notice in December 2012 in order to have a valid removal, you would have to have sent a special notice of removal pursuant to the statute, which we discussed. Basically, this is a mouthful here, but basically what this is saying is that 99 times out of 100, deductions that are validly in place on March 1st of a year will stay in place for that whole tax cycle, even if property changes hands during that year and the new owner is ineligible. Okay, that's the rule of thumb, 99 times out of 100. But with the verification form, this is sort of an exception to that, because it is possible that even if the homestead deduction was in place on March 1st, 2012, and a new owner purchased the property from the seller later that year, that new owner might think, well, the deduction will stay in place for the whole cycle, even though I'm not eligible for it, because the previous owner had it in place on March 1st, and so I'm home free. But there is the possibility that that deduction could be pulled for 12 pay 13, and that new owner won't enjoy the benefit of it. So again, that's kind of a narrow exception. Keep that in mind. You might encounter that. Again, most of the time, deductions stay in place for the whole tax cycle, even if somebody buys the property later in the year and they're not eligible. This is kind of a nuance, an exception to that. The last point I make here is that if the buyer can get the seller to come in and provide proof of his or her eligibility, then the deduction would have to be reinstated, and then that new owner would end up enjoying the benefit of that deduction for that cycle. All right, so again, it goes back to the earlier slides where I was saying if the owner comes in and provides proof of eligibility, it has to be reinstated. Now this slide here, I may be OCD about many things, and kind of as the contact person for the state about deductions, this is something that is kind of a pet peeve of mine. But beyond that, there is also an important legal distinction between deductions and exemptions and credits. A deduction reduces the AV being taxed. An exemption excludes property from assessment and/or taxation, and a credit reduces the tax bill. All right, so there's no such thing as a homestead exemption. There's no such thing as a veteran's exemption. And again, it's, part of it is my OCD, but the other part of it is that these things work differently. There are different laws that govern exemptions and deductions. They work differently. So it is important to get the terminology right. And just a couple other bullet points. This presentation, other things the DLGF produces, memos and other things, are simply meant to be informative or helpful, but they're not a substitute for the law. So sometimes a taxpayer or government official will, pull some memo that we issued 7 years ago and say, well, you said on page 7 X, Y, and Z. Well, sometimes laws change. Sometimes, fact patterns are very subtle and nuanced. So, these are just meant to be helpful and informative. The law, of course, always governs in all cases. And the last point there, if you're not sure about something, please ask first. We're happy to answer questions you may have. We try to be as responsive as possible. And if we can't help you, we'll refer you to the right agency or authority, or perhaps to your county attorney. There are some things that are just beyond our expertise, and your county attorney can certainly provide you with legal advice. We can't give you legal advice. We can just help explain what the law says. And most importantly, do not rely on rumors or information from dubious third parties. Contact us, talk to your county attorney first. Don't just rely on rumors or, just kind of guess. Contact us first. We're happy to help. All right. I think I touched on this first bullet point here, but if a deduction is validly in place as of March 1st, it will stay in place for the assessment year, even if the property changes hands, the new owner isn't eligible for it. Exemptions come off during the same cycle, and that's why it's important to distinguish between deductions and exemptions and use the right terminology. If property is exempt as of March 1st, but then it is sold to a non-exempt entity in that same year, the exemption comes off for that year. So exemptions and deductions work rather differently, and so that's why it's important to distinguish between them. Now, what if a person has a homestead in his principal place of residence on March 1st, but moves to a new principal place of residence later in the year? There is a subsection to the homestead deduction statute, and I've provided that here for you, subsection H. And this creates a scenario where it is possible for a person who moves from a homestead to another homestead in Indiana within the same tax cycle could receive a homestead deduction on both properties for just that cycle. Obviously, for the next tax cycle, the deduction comes off that old property. But this is kind of an interesting nuance. Maybe you've encountered, or maybe you will. But it is possible for someone to get 2 homestead deductions for the same cycle if they've moved from one homestead to another in the same cycle. All right, now this next question here is not really related to the homestead deduction or verification program, but I've received it many times, and I think there's some inconsistency in the way that counties are handling this. But can one spouse or owner receive an over 65 deduction while the other spouse or owner receives a veteran deduction? And the answer is yes. State law prohibits the same person from receiving an over 65 deduction and certain other deductions, but it does not prohibit one spouse or owner from receiving an over 65 deduction and another spouse or owner receiving a disability or veteran deduction. Please note that the fractional reduction in the over 65 deduction only occurs if the other owner is not 65 and not the applicant's spouse. If the applicant's spouse is under 65, there is no reduction. So in other words, if we're talking about the same person trying to apply for an over 65 deduction and a veteran deduction, that can happen, all right? But if you have one spouse applying for a veteran deduction and the other spouse applying for the over 65 deduction, each spouse can receive the full amount of those deductions and apply them to the same property, all right? State law prohibits the same individual from receiving certain combinations of deductions. And also on the over 65 deduction, if the applicant is over 65, but there are other owners on the property who are not the spouse and who are under 65, then there's a fractional reduction that you have to apply to that person's over 65 deduction. But if the other owner, even if they're under 65, if the other owner is the spouse of the applicant, then there is no reduction. All right, so the reduction only occurs if the co-owners are not the spouse of the applicant. Now remember that a homestead deduction applies to a dwelling in up to 1 acre surrounding that dwelling. Even if that acre straddles or overlaps 2 or more parcels, the deduction must be applied to that full acre. The fact that the acre straddles or overlaps multiple parcels doesn't preclude the taxpayer from receiving a complete deduction on that acre. I've got many calls about situations where someone owns 2 or 3 parcels and the dwelling's on one of them, but then the acre is, kind of overlaps the other parcels. And some counties only seem to give the deduction on that parcel where the dwelling is located. But the taxpayer is entitled to the deduction on that full acre, even if it overlaps multiple parcels. So somehow you'll have to, even if it's 20 feet of one parcel, you'll have to somehow portion that out to make sure the taxpayer gets the full deduction. All right. I think the next few slides I've already presented last year. This is talking about trusts and some divorce situations and LLCs. I want to make sure that Eric has some time to talk about his topics, so I'm not going to dwell too much on those. I think the last slide that I'll address in this presentation, in 2012 there was a legislative change that provides as follows. If a property owner's property is not eligible for the deduction because the county auditor has determined that the property is not the property owner's principal place of residence, the property owner may appeal the county auditor's determination at the PETA BOA. The county auditor must inform the property owner of the owner's right to appeal to the PETA BOA when the county auditor informs the property owner of the county auditor's determination. This was effective July 1st, 2012. So normally, if you deny a deduction application, normally you don't have to notify the taxpayer. The 2 times that you do that are relevant to this particular presentation, number 1, if someone failed to file the pink form and you're going to terminate the deduction, you have to notify them before you do that. The other circumstance is if you get a homestead deduction application from someone and you determine that they're not eligible, I think what this legislative change is saying is that you have to notify them of the denial, and in that notification you have to inform them of their right to appeal to the PETA BOA. All right, so it's not explicitly spelled out that you have to notify, but I think it's there. I think it's implied that you do have to notify the taxpayer and inform them of their right to appeal to the PETA BOA. And again, that was effective July 1st, 2012. This is my contact info. Email is always preferred because if there's a fact pattern or something, it's a little bit easier to kind of sit and digest it by email than over the phone, and I can always share it with colleagues for their input. So that's my contact info, and thanks for your attention, and I'll turn it over to Eric now.